And welcome to our webinar on the Corporate Insolvency and Governance Bill, which was published on the 20th of May this year. My name is Caroline Benfield, and I am a partner and head of insolvency at Wright Hassall. And my colleague Elizabeth Taylor, who is a consultant in the insolvency team, will also be talking us through the bill today. Now, we're going to be providing you with an overview of some of the important aspects of the bill, and in particular, Liz is going to talk us through the moratorium and the temporary measures concerning wrongful trading and the restrictions on the use of winding up petitions. I will then take us through the provisions concerning the restructuring plan, termination clauses in supply contracts, and the temporary measures concerning company meetings and filings. So I'm now going to hand over to Liz to start the webinar. Thank you, Liz.
Hello everybody and welcome. As Caroline mentioned, I'm going to be talking to you about the new moratorium provisions and the temporary provisions dealing with winding up proceedings and wrongful trading. But before I do that, just a couple of words on the progress of this bill through Parliament. The bill has so far completed 3 readings in the House of Commons. It's had 2 readings in the House of Lords, the most recent on the 9th of June. It was due to have its committee stage on the 16th of June and its final reading in the House of Lords on the 23rd of June. And it's expected to come into force at the end of June or early July. I am aware, however, that there have been some amendments proposed to the bill by the House of Lords, one of which is in connection with wrongful trading, which I will come on to later in this presentation. So it's important to emphasise that what we have before us today is not necessarily going to be the final version of the bill. So we're going to have to wait and see what the final version looks like when it comes into force. Certain aspects of this bill have been subject to consultation for many years, going back to 2016. Dealing with particularly the moratorium, the schemes of arrangement and the termination provisions. But other aspects of the bill have been drafted in response to the various government announcements dealing with the measures they wish to introduce to mitigate the effects of the coronavirus pandemic. And wishing no disrespect to the parliamentary draftsman, I do think that that shows in the way that some of the legislation has been shoehorned into the original draft bill, particularly the winding up proceedings and the wrongful trading. My favourite section of the bill is section 18.2, which says that regulations under this section may make different provision for different purposes. And what that means is that the government has reserved the right to change any of the bill if, when it comes into effect, it's found that it doesn't achieve the end that it was designed to achieve because it's been put together quickly. So even if amendments are not made at this stage as the bill is passing through Parliament, it is possible that during the course of the next 6 months, we may see further regulations changing or clarifying some of the provisions. So coming on to deal with the moratorium, section 1 of the bill inserts a new part A1, which will come before part 1 of the Insolvency Act 1986. The eligibility criteria are set out in a new Schedule ZA1, which is at Schedule 1 of the bill and replaces existing Schedule A1, which is the schedule dealing with the existing CVA moratorium process. So I hope you're still with me at this point. Schedule 3 sets out a list of amendments to the Insolvency Act, and Schedule 4 contains a set of temporary rules which expire at the end of the relevant period, and the relevant period is the end of June or 1 month after the coming into effect of this legislation, whichever is the later. And I assume that at that point there will be some permanent rules, but we're not told that that's going to be the case, but you know, I assume that that must be going to happen. And the rules will deal with time limits, service of notices and other procedural aspects as the 2016 rules currently do. So eligibility, the companies who are eligible for the moratorium are basically all registered and unregistered companies, LLPs and certain overseas companies. All of the rules that we previously had in relation to CVA moratoriums dealing with small companies have gone. So there are no size limits applying to the companies who are eligible for the moratorium. There are certain exclusions. There's a long list of various insurance and financial type institutions who are not going to be eligible, but generally speaking, it's all companies. The monitor obviously plays a very critical role in this process. The monitor is an officer of the court, a licensed insolvency practitioner, and he has a duty to monitor the affairs of the company throughout the moratorium process to confirm and to maintain his view that the company is likely to be able to be rescued as a going concern. And as I'll allude to many times in this presentation, that in my view is a very high threshold. But it's important to emphasise that the directors remain in control of the company during the moratorium period, and the role of the monitor is simply to monitor the company's performance during this period to confirm his view that it remains likely that it can be rescued. The monitor can rely upon information provided by the company, provided he's got no reason to believe that it's inaccurate. He can request information from the directors at any time, and the directors have a duty to provide that information as soon as practical. If the monitor's view changes at any point, then he must file a notice in court, which will have effect to terminate the moratorium. And there are also provisions dealing with any challenges to the monitor's conduct during this period, to challenge his remuneration in certain circumstances where the company subsequently goes into liquidation or administration, and generally to challenge his decisions throughout the moratorium period. So in terms of the process of applying for a moratorium, there is an out-of-court process and a court application process. The out-of-court process applies where there is no outstanding winding up petition. The directors are required to file at court a notice seeking the moratorium, and that notice must be accompanied by a statement from the directors that the company is or is likely to become unable to pay its debts. There must also be a statement from the monitor to say that he is qualified, he consents to act, that the company is eligible for the moratorium, and that in his view the company is likely to be rescued as a going concern. So that mirrors that test that the company is likely to be rescued as a going concern. It mirrors the first objective in the administration process, but unlike administration, that is the sole objective of the moratorium. And that is why, in my view, I believe that it's a very high threshold. Where there is an outstanding winding up petition, the process for seeking the moratorium is exactly the same, except that instead of filing a notice, it's necessary to file a court application. All of the other supporting documents are exactly the same. It isn't clear at this stage whether the court will treat the application as urgent and list it for hearing straight away or as soon as possible, or whether the court will list the application to be heard at the same time but immediately before the hearing of the petition. I suspect the court's going to treat this as an urgent application because it does seem clear from the way other aspects of this bill have been drafted that there is an expectation that there'll be a lengthy delay between the issue of the petition and the hearing of the petition. But we don't know, and we're just going to have to wait and see. So when the court hears the application, the court can make such order as it thinks fit, and the court will only order a moratorium if satisfied that the outcome will be better for the unsecured creditors than would be the case in the event of a winding up. It's hard to imagine how the court could come to a different conclusion at this point, bearing in mind the statement that the monitor has had to make that it's likely that the company will be rescued as a going concern, because a rescue is always going to be better for the creditors than a winding up. The duration of the moratorium is 20 days initially, And that's a reduction from the period that we saw in the consultation process. It was originally proposed that the period would be 28 days, but for reasons which are not clear, that duration is now going to be 20 days. So, extensions to the moratorium. The moratorium can be extended with or without creditor consent, and also by the court. The directors can seek an extension of the moratorium once without creditor consent, and they do that by filing a notice in court after 15 days into the original 20-day moratorium period. And they have to accompany that notice with a statement to say that all the post-moratorium debts have been paid and all pre-moratorium debts have been paid for which there is no payment holiday. The debts for which there is a payment holiday is basically all debts. So the debts for which there is no payment holiday, which also have to be paid, are the monitor's remuneration, any supplies made during the moratorium period, rent apportioned during the moratorium period, and any wages or salary accruing during the moratorium period. And finally, any contractual debts or liabilities in relation to any financial products during this period. It's also necessary for the monitor to file a statement to say that the company remains likely to be rescued as a going concern. But there is an additional statement to be added here, which appears in the temporary rules, which says that the company would be likely to be rescued as a going concern, but for the worsening of the financial position of the company due to the coronavirus pandemic. So it remains to be seen whether those temporary words remain in the final version of the rules, because obviously that isn't something that's going to apply once we're out of the coronavirus pandemic. So we'll have to wait and see what the permanent rules say when those are published in due course. So the moratorium, if extended without creditor consent, lasts for a further period of 20 days, beginning with day 21, so after the expiry of the initial 20-day period. The process for extending the moratorium with creditor consent is the same, except that in addition to the documentation that's needed to be filed, the directors must file confirmation that creditors have been consulted and the length of time that the creditors have agreed to extend the moratorium. And the creditors reach that decision using a qualifying decision-making procedure. Where the court made the initial moratorium, the court must make any extension to the moratorium. So where there was a winding up petition such that the original moratorium was made by the court, an application to court must be made to extend the moratorium. And the process is the same, except that rather than filing a notice, it's an application. But it's also necessary to confirm whether or not creditors have been consulted in relation to the extension, and if not, why not? So in practical terms, it's always going to be appropriate to consult with creditors at this point. And in my opinion, the outcome of that consultation should be filed at court with the other documents that need to be filed. The court can extend again to such period as it thinks fit. And in reaching its decision, the court must consider the interests of the pre-moratorium creditors and the likelihood of the company being rescued as a going concern. Now, it's quite unlikely, in my view, that the court would disagree with the statement that the monitor has made at this point, because the court has got no other information to go on. The rules dealing with the information that the monitor has to file actually are very short, and there's no requirement for the monitor to file detailed information as to the basis upon which he's formed his opinion, which is interesting. the rules only stipulate that the monitor needs to file details of his IP number, RPB and consent to act. So it'll be interesting to see whether there's any amendments to these rules when we see the final version of the bill, or whether that is changed in the permanent rules as and when those are published. The moratorium is also extended automatically where a CVA is proposed during the moratorium period, and in those circumstances the moratorium is automatically extended until the date that the CVA is approved or rejected. And where there is an application for one of the new schemes, which Caroline will come on to deal with, the court also has a power to create or extend the moratorium. So coming on to deal with termination of the moratorium, the moratorium will expire at the end of the period for which it has been granted. But it will also expire when the company enters a formal insolvency process. Now, obviously, the moratorium itself prevents any creditor-instigated insolvency process. And so the only circumstances in which the moratorium will end are with a director-instigated insolvency process. So that would be a director's compulsory petition, a CVL, or notice of intention or notice of appointment of administrators filed by the directors. Interestingly, a notice of intention or a notice of appointment filed by the company itself does not bring the moratorium to an end. I'm not quite sure why that would be, whether that's a drafting oversight, but it is only a process instigated by the directors that has the effect of ending the moratorium. So coming on to deal with the effects of the moratorium, they are the same as the effects of the moratorium in an administration. So I won't go through all of those, but there are some additional effects, which are that the company cannot obtain credit exceeding £500 without disclosing the existence of the moratorium. The company can grant security during the moratorium period, provided that the monitor consents, and that security can subsequently be enforced. There are some restrictions on payment of pre-moratorium debts. The company cannot make payments exceeding £5,000 or 1% of the company's unsecured debt, whichever is the greater, in respect of pre-moratorium debts where there is no payment holiday, without the consent of the monitor or an order from the court. But interesting, there is a requirement for those debts to be paid as a condition of extending the moratorium. So it's hard to imagine a situation where the monitor would not consent to those payments being made. There are restrictions on disposal of company property during the moratorium period. Company property cannot be disposed of unless it's in the ordinary course of business, the monitor consents, or there is an order from the court. And there are provisions dealing with disposal of charged property, which mirror the provisions of Schedule B1 in the administration context. Schedule 3 of the bill introduces a new Section 174A of the Insolvency Act 1986, which has the effect of creating a super preferential status for certain debts. So where winding up proceedings commence, and that can be compulsory or CVL, within 12 weeks of the end of the moratorium, the official receiver's fees, moratorium and pre-moratorium debts for which there is no payment holiday, all have priority over the fees of any subsequently appointed liquidator and ahead of preferential and floating charge creditors. And Rule 42 of the temporary rules sets out the order of priority of those pre-moratorium debts. So if you are a liquidator coming in at this late stage, then or you're asked to take an appointment in these circumstances, and it seems to me that that's not a very attractive prospect. So that comes to the end of this section on the new moratorium provisions. And as I've said a couple of times, I do think that it's a very high threshold for companies to meet, the requirement for it to be likely, not possible, but likely that the company will be capable of being rescued as a going concern, and for the company to have sufficient cash during the moratorium period to keep paying the majority of its debts during that period. So it remains to be seen how widely this new process is going to be used. So next I'm going to talk about the new temporary winding up provisions. Section 8 of the bill refers to Schedule 10 of the bill, and all of these temporary provisions are set out in Schedule 10. When these provisions were first signalled during one of the coronavirus daily updates, there was a reference to a prohibition on the service of statutory demands and winding up petitions in respect of unpaid rent during the coronavirus period. But what we have here is very significantly wider than that. And there was no indication given back in April that provisions as wide as this were going to be incorporated into the legislation. So what the new provisions say is that a creditor cannot issue a winding up petition based upon a statutory demand served during the relevant period. And the relevant period is defined as the 1st of March 2020 to the 30th of June 2020, or 1 month after the bill comes into force, whichever is the later. So there is no limit to this. There's no limit to any specific category of debt. This applies to all categories of debt. There is no ban, however, on the service on the issue of a winding up petition based upon a statutory demand served prior to the 1st of March. But obviously we're now 3 months beyond that, and any winding up petition served on the basis of a statutory demand that's more than 4 months old is it's doubtful as to whether non-compliance with that demand is evidence of insolvency. But there's also no ban on the issue of a winding up petition based on any other ground, for example, failure to execute a judgment debt or other evidence that the company is unable to pay its debts. And it isn't clear whether that's a drafting oversight that will be corrected during the passage of the bill through Parliament or in any subsequent amendments to the legislation. So coming on to petitions, a creditor cannot present a winding up petition during the relevant period, which for this section of the rules is defined as on or after the 24th of April 2020. A creditor cannot present a petition during this period unless they satisfy what is going to become called the coronavirus test. And what that means is that creditors must include within the petition a statement to the effect that they, the creditor, has reasonable ground for believing that coronavirus has had no financial effect on the debtor, or that the debt would have arisen anyway. And the new insolvency, the temporary rules contain a provision requiring that mandatory statement in any petition issued during this period. But it strikes me that it's going to be very difficult for the creditor to be able to make that statement, bearing in mind that it's not his business that he's talking about. It also strikes me that coronavirus has had an effect on virtually every business in this country. So yes, it's not really quite clear how that condition is going to be satisfied. It's also not clear who is going to be scrutinising the petitions when they're received into the court office. Is it going to be the court staff, or is it going to be a member of the judiciary? when I heard a member of the judiciary speaking about this before the bill was published, she didn't have any idea because there had been no consultation on this particular aspect. And I very much doubt whether the judiciary are going to have time to scrutinise every petition. And I would also suggest that if the petitions are going to be scrutinised by a member of the court office staff, the level of scrutiny is likely to be quite low. But again, we're just going to have to wait and see. It's also important to emphasise that the relevant period for which these provisions apply could be subject to change. At the moment, it's from the 27th of April until the coming into force, or 1 month after, but that could be extended. So, where a petition is received into the court office, if the court is satisfied that the coronavirus test is not satisfied, the court can restore the petition to what it would have been had the petition not been sent to the court. It isn't entirely clear how that provision is going to operate in practice, because at this particular point the petition has not been issued. It's simply been sent into the court office for scrutiny, but that's what the provision says. There can be no advertisement of the petition at this point, and no ability to inspect the court file. Those provisions are suspended until such point as the petition is actually issued. So where the petition does pass the coronavirus test and is issued by the court, if the court believes when at the hearing of the petition that in fact the coronavirus test wasn't satisfied, the court can still make a winding up order if satisfied that other grounds existed. Now, these provisions, when they're enacted, are going to be backdated to the 27th of April. And what that means is that from the 27th of April onwards, winding up orders could very well have been made. And the next set of provisions are therefore likely to have profound consequences. So where a winding up order was made on or after the 27th of April, but the court takes a view that had these provisions been in place at the time the order was made, the court would not have made the order. The court is deemed to have had no power to make the order at the relevant time, and therefore the winding up order is void. Luckily, there is no liability attaching to the official receiver or the liquidator for any steps that they have taken since the order was made. And the court can make such order as it thinks fit for restoring the company to the position that it would have been in had the order not been made. I'm not entirely sure how that is going to be possible, because if a winding up order was made back in May, for example, the staff will have gone, the premises are likely to have gone, the business will have come to an end. So it seems to me that it's going to be impossible for the company to be restored to the position that it would have been in had the order not been made, but that is what the provisions say. It's also not clear what provision is going to be made for payment of any costs that have been accrued during this period by the official receiver or the liquidator. There is a suggestion that those costs could fall to be paid by the petitioning creditor, because realistically there's nobody else that can pay those costs, and any work that's been undertaken by the official receiver or the liquidator has been properly undertaken. So we don't know the answer to that question, and it may be that it results in a substantial amount of litigation, but we will just have to wait and see. Now, another change introduced here in this section of the bill relates to the date of commencement of the winding up during this period. So where a winding up order is made on or after the 27th of April, the date of commencement of the winding up is deemed to be the date of the winding up order not the date of the petition. And in practical terms, that means that Section 127, which is avoidance of post-petition dispositions, has no effect, because those provisions, Section 127, only applies to dispositions of company property made between the date of petition and the date of the order. If the date of commencement of winding up is going to be the date of the order, then Section 127 has no application. There are also changes to the relevant dates for the purpose of various offences under the Insolvency Act and the avoidance of prior transactions. So where, for example, in the case of transactions at undervalue, the liquidator will be looking back at the period of 2 years commencing with the onset of insolvency, which traditionally would be the date of commencement of the petition. The rules are now changed so that the relevant period looking back is 2 years from the date of the petition, or 2 days and 6 months from the date of the order, whichever is later. And we see the same provisions in respect of preferences, where you've got 6 months or 2 years, avoidance of certain floating charges, where you've got 12 months or 2 years. You're adding on, in all of those cases, the alternative date of the 6 months prior to the petition, whichever is the later. And the reason for that is because the government clearly envisages that there is going to be a lengthy delay between the issue of the petition and the making of a winding up order, which is the same reason why I felt that in respect of the moratorium application, the court would be likely to hear that application sooner rather than waiting until the date of the petition hearing. So that comes to the end of this section on the new winding up provisions. I'm now going to look at the new wrongful trading provisions, and these are introduced in section 10 of the bill. And what the new provision says, and I've put this on the slide, is that for the purpose of determining a contribution to the company's assets that it is proper for a person to make, the court is to assume that a person is not liable for any worsening of the financial position of the company or its creditors that occurs during the relevant period. And the relevant period is the 1st of March 2020 to the 30th of June 2020, or 1 month after the bill comes into effect, whichever is the later. Now, when this change to wrongful trading was first announced by the government, there was a lot of criticism from within the insolvency profession and a lot of scepticism, as it was thought that this would be wide open to abuse. And when I heard comments from the judiciary on this, they said that they thought the courts would be likely to adopt a very robust approach to these provisions in order to ensure that they weren't subject to misuse. However, when you look at the way this particular provision has been drafted, there is no reference here at all to the coronavirus. The provisions are drafted purely and simply by reference to that particular date range of the 1st of March 20 to the 30th of June 2020. And what that means is that there is no scope for discretion whatsoever. The liquidator or administrator simply cannot bring wrongful trading proceedings seeking a contribution from the director in respect of any deterioration in the company's financial position during this range of dates. What this bill has not done, however, is make any changes to the provisions in the Company Directors Disqualification Act, which allow the court to make a compensation order where the court finds, in the context of those proceedings, that the director has been liable for wrongful trading. However, I very much doubt that the court would be prepared to make a compensation order in those circumstances, because to do so, it seems to me, would go very much against the spirit of this particular piece of legislation. Now, I did here, however, that when this bill was being debated in the House of Lords, the Lords proposed an amendment to the wording up on the screen here, so that rather than there being an assumption that a person is not responsible, that would be changed to a presumption, which would then be capable of being rebutted on the evidence. I don't know at this point whether that amendment is going to make the statute book. We will just have to wait and see. It's also important to emphasise that the other directors' duties remain unchanged, so it's still possible to scrutinise the conduct of the directors during this period to see whether there could be any misfeasance or breach of duty, and all of the directors' duties under the Companies Act remain in force. So that concludes my section and my presentation, and I'm now going to hand over to Caroline Benfield, who's going to talk to us about the new schemes of arrangement and the termination provisions in the bill. Caroline.
Lovely, thank you very much, Liz. So as Liz has just mentioned, I'm going to start by talking through the provisions concerning the new restructuring plan. So Clause 7 and Schedule 9 of the bill introduce a new Part 26A into the Companies Act, pursuant to which a company in financial difficulty can propose a restructuring plan, which allows it to compromise certain creditors or classes of creditors or members or classes of members. Now, a restructuring plan is an alternative tool to a CVA and a scheme of arrangement, albeit it will operate much in the same way that the current scheme mechanism does, and much of the practical machinery of a restructuring plan is based on the process for a scheme of arrangement. You'll all be very aware that the scheme of arrangement procedure is predominantly used to undertake the restructuring of companies with complex capital arrangements. It's flexible and has been used in increasingly creative ways to address a variety of financial challenges faced by companies and give them an improved chance of future viability. However, it does lack a key feature which limits its effectiveness and puts it at a disadvantage compared to the restructuring frameworks of a number of other jurisdictions, such as the US Chapter 11 model, and that is the cross-class cram-down. Without the cross-class cram-down, a single class of creditor can block a scheme from being agreed, even when it's in the company's interests. So whilst a restructuring plan is similar to a scheme of arrangement, it includes the ability for a company to bind a class of creditor or member to a restructuring plan, even where not all classes have voted in favour of it, provided that the restructuring plan is fair and equitable. Unlike a CVA, it will have the ability to bind both secured and unsecured creditors. A restructuring plan is going to be available for every creditor which is liable to be wound up under the Insolvency Act, which includes foreign companies. And a restructuring plan is going to be available to companies who satisfy two conditions. And what I'm going to do is I'm going to read out these conditions. The first condition is condition A, which is that the company's encountered or is likely to encounter financial difficulties that are affecting or will or may affect its ability to carry on business as a going concern. And then condition B, which is that a compromise or arrangement is proposed between the company and its creditors or any class of them, or its members or any class of them. And the purpose of the compromise or arrangement is to eliminate, reduce, or prevent or mitigate the effect of any of the financial difficulties mentioned in subsection 2, which is condition A. So those are the two conditions that need to be satisfied in order for a company to be entitled to operate a restructuring plan. Turning to the process to approve a restructuring plan, it is similar to a scheme of arrangement, and that is an application to court for permission to convene a meeting of creditors or members or classes of each, followed by a meeting at which members and or creditors will vote on whether to approve the restructuring plan and then a further application to court to ask it to exercise its discretion to sanction the restructuring plan. The application can be made by the company, any creditor or member of the company, or if the company is being wound up, the liquidator, or if the company is in administration, the administrator. All creditors or members who are affected by the compromise or arrangement must be permitted to participate in the meeting unless the court is satisfied that no member of the relevant class has a genuine economic interest in the company. Now, in the bill, there is no specific test set out for the court to apply when approving the restructuring plan, but I suspect that a similar approach might be taken as that for schemes of arrangement, namely checking that it is being voted through in accordance with the legislation. Those voting in favour were not, for example, receiving ancillary benefits for voting in favour, which may have influenced their decision, and that ultimately the restructuring plan is fair. The statement to be circulated or made available. Now, every notice summoning a meeting that is sent to a creditor or member must be accompanied by a statement, and it must explain the effect of the compromise or arrangement. It also must explain any material interests of the director of the company and the effect of those interests on the compromise or arrangement insofar as those are different from the effect on the like interests of other persons. Then turning to the court sanction for the arrangement, if 75% in value of the creditors or members or classes of each, whichever might be relevant, present and voting, and that's either in person or by proxy at the meeting, if they agree the compromise or arrangement, then the court may sanction it. And where the court makes an order in relation to a company that's in administration or is being wound up, the court may order for the appointment of the administrator or liquidator to cease to have effect. The court may also stay or cease all proceedings in the administration or winding up. And it may also impose any requirements with respect to the conduct of the administration or the winding up, which the court thinks appropriate for facilitating the compromise or arrangement. A compromise or arrangement which is sanctioned by the court is binding on all creditors, all class of creditors, or on members or class of members, whatever is relevant, and on the company, but it's important to bear in mind that the order will not have effect until a copy of it has been delivered to the registrar. Now, when dealing with dissenting creditors or members, if there are dissenting creditors or members or classes of each as relevant, the court can still sanction the plan if two conditions are. And the first condition that needs to be met is that the court is satisfied that if the compromise or arrangement were to be sanctioned, then none of the members of the dissenting class would be any worse off than they would be in the event of the relevant alternative. And within the bill, the term relevant alternative is explained to mean that whatever the court considers would be most likely to occur in relation to the company, the compromise or arrangement were not sanctioned. The second condition that needs to be met is that the compromise or arrangement has been agreed by a number representing 75% in value of a class of creditor or member present and voting either in person or by proxy, who would receive a payment or have a genuine economic interest in the company in the event of the relevant alternative. So what this means is that where a class does not vote in favour, the court will still be able to sanction the restructuring plan, provided the class or classes that voted against it are no worse off than they would be if the compromise were not sanctioned, and at least one class of creditor who would receive something if the compromise wasn't sanctioned voted in favour of it. So I've just got a couple of observations on restructuring plans. A potential issue for dispute might be what is considered to be the relevant alternative, as I've explained previously, or how that should be, what that should be regarded as. Now, if the court is persuaded that administration or liquidation is a relevant alternative, then the threshold for satisfying the no worse off test is at risk of being quite low. Now, the court has absolute discretion whether to sanction the restructuring plan and may refuse to sanction it if it's equitable and just to do so. So it's likely that valuation evidence is going to play a central role as the company will need to demonstrate where value breaks to exclude creditors or members from voting or participating in the restructuring plan, as well as to satisfy the court that the cross-class cram-down, the assenting class members are no worse off. So I'm now going to turn to termination clauses in supply contracts. The bill introduces a disapplication of the rights of a supplier to terminate a contract as a result of the company's insolvency. The policy intention behind the new provisions was to help companies trade through a restructuring or insolvency procedure and to maximise the opportunity for rescue of the company or the sale of the business to going concern. Now, you'll all be very aware that the current law already provides some protection for insolvent companies against certain suppliers who provide essential goods and services, for example, utilities. But the bill broadens the scope of these restrictions to a wider range of suppliers. Clause 12B of the bill introduces a new section 233B into the Insolvency Act. And the section applies where a company becomes subject to a relevant insolvency procedure, which includes the moratorium under Part A1 that Liz has already spoken about. A company entering administration, an administrative receiver being appointed, a voluntary arrangement being approved, a company going into liquidation, or a provisional liquidator being appointed. Under section 233B, subsection 3, a provision in a contract for the supply of goods or services will cease to have effect when a company becomes subject to an insolvency procedure if under the provision, the contract or the supply would terminate because the company becomes subject to the relevant insolvency procedure, or the supplier would be entitled to terminate the contract or the supply or do any other thing because the company becomes subject to the insolvency procedure. So what this effectively means is that there will be a prohibition on the reliance by suppliers of termination clauses in contracts for the supply of goods or services that are triggered when a party's entered into a formal insolvency procedure. Now, the wording "any other thing" is not defined, and as far as I'm aware, the government explanatory notes provide just one example, which is that changing payment terms will be prohibited. But the wording is broad and potentially captures the exercise of any contractual right triggered upon an event of insolvency. Now, where under a provision of a contract for the supply of goods or services, the supplier is entitled to terminate the contract or the supply because of an event occurring before the start of the insolvency period, and that entitlement arose before the start of the insolvency period, that entitlement may not be exercised during the insolvency period. However, for new breaches which happen after the insolvency procedure begins, suppliers will still be allowed to terminate. Further, a supplier will be able to terminate a contract if, in the case of the company being in administration or liquidation, or if an administrative receiver or provisional liquidator is appointed, the office holder consents. But if the company is in, for example, a voluntary arrangement, then the company can consent, or if the court is satisfied that the continuation of the supply would cause the company hardship. Now, again, hardship is not defined in the bill and may well need to be resolved by the courts going forward. What is also built into the bill is provision restricting a supplier from requiring pre-insolvency debts to be paid as a condition of making further supplies. There will also be a new Schedule 4ZZA of the Insolvency Act, which includes a long list of excluded companies and particular types of contracts, including certain financial institutions and various financial and capital market contracts. The exclusions capture lending contracts, so there's no obligation on lenders to continue to supply finance to companies in a relevant insolvency procedure. The new provisions will apply where the insolvency procedure commences on or after the day on which the provision comes into force, and they will apply in respect to contracts entered into before as well as after that date. Built into the bill is temporary exclusion for small suppliers where the insolvency procedure occurs during the relevant period. And for these purposes, the relevant period is the date the bill comes into force until the later of the 30th of June 2020 or 1 month after the bill coming into force, so whichever is the later date. Now, to qualify as a small supplier where it is not in its first financial year at the relevant time, at least 2 of the following conditions of the 3 prescribed conditions need to be met. And these conditions are that its turnover must not be more than 10.2 million, its balance sheet should be not more than 5.1 million, and the number of employees must not be more than 50. Now, where the supplier is in its first financial year at the relevant time, it will qualify as a small entity if at least 2 of the following 3 prescribed conditions are met. And that is the supplier's turnover for each complete month in the first financial year is not more than £850,000. The aggregate amounts which would be shown in its balance sheet at the relevant time is not more than 5.1 million. And the average number of persons employed by the supplier in the supplier's first financial year is not more than 50. Now, the temporary exclusion was likely designed to soften the impact for small businesses in the short term, but obviously once the relevant period has expired and subject to whether there's going to be any extension on that, it is likely to apply to all suppliers, and therefore it's going to be important that they manage their credit control processes carefully so that they don't accrue bad debt. It also remains to be seen how these provisions will work in practice and how some of the less precise terms are going to be interpreted by the courts. However, we're all very aware that the court's resources at the moment are stretched and being tested, which of course may dissuade suppliers from applying to court for permissions for their contracts to be terminated under the hardship exemption, perhaps leaving them to try and reach consensual arrangements with the company or its office holders. So finally, I'm going to turn to company meetings and filings, and I'm just going to provide a very, very quick overview of what's provided in the bill in this regard. The legislation was introduced to address the difficulties faced by companies as a result of the pandemic when it comes to holding meetings of shareholders and the filing of documents at Companies House. It's hoped it will provide companies with more practical options for holding AGMs and other shareholder meetings while social distancing measures remain in place across the UK. So turning first to meetings, the provisions on meetings in the bill apply to all companies, and the flexibility will therefore assist not just public companies that must hold an AGM because the Companies Act 2006 requires them to do so, but also private companies whose articles of association oblige them to hold an AGM. The temporary provisions apply to meetings held between the 26th of March this year and the 30th of September. And they can be amended by subsequent regulations to shorten that 30th of September date or extend it by periods of up to 3 months, but not beyond the 5th of April of next year. The provisions are designed to apply retrospectively so that proceedings at meetings held after the 26th of March may be validated if they would otherwise be in breach of legal requirements and the provisions of the company's constitution. Under the bill, all companies which are obliged to hold an AGM within a certain time frame will have until the 30th of September of this year to hold its AGM. And with regard to meetings of shareholders, those meetings do not need to be held in a particular place and may be held by electronic means. The specified quorum does not need to be present in the same place, and votes can be cast by electronic or other means. Shareholders will not have the right to attend a meeting in person or participate in any meetings other than to vote during this period. Now, but it is also important to bear in mind that the legislation will give temporary relaxations only. So companies would be advised to review their articles and to think about possible amendments that they would like to make, such as the ability to hold hybrid meetings, which will give them more flexibility in the holding of shareholder meetings in future. Turning then to filings, you'll all be aware that companies are required to file prescribed documents by fixed deadlines at Companies House each year, and that missing the deadlines can result in financial penalty and in criminal sanctions for company directors, or, for example, the company being struck off the register of companies. And extensions of time have already been offered to companies, but the bill contains measures to extend various statutory deadlines for companies looking to file certain information at Companies House. So with regard to the filing of statutory accounts, the bill provides for a temporary extension to the period within which a company must file its accounts and reports with Companies House, where such accounts are required to be filed between the 26th of March and the 30th of September. Under the bill, a public company may delay its annual report and accounts to the earlier of the 30th of September or the last day of the period of 12 months immediately following the end of its accounting reference period. And with regard to routine corporate filings, the bill enables the Secretary of State to make regulations to temporarily extend the deadline for routine filings at Companies House. And this includes annual confirmation statements and, for example, to register a legal charge. If the company filing periods are shorter than 21 days, further temporary regulations may be introduced to extend the filing deadline by up to 42 days, and for filing periods between 3 to 9 months for up to 12 months. And the bill provides for such powers to expire on the 5th of April 2021. So that is everything that I'd like to mention at this stage concerning what's contained within company meetings and filings, and brings our webinar to an end. We have produced on our final slide the contact details for Liz and I. As it's explained within this slide, I'm a partner and head of the insolvency team at Wright Hassall, and my colleague Liz, the consultant within the insolvency team at Wright Hassall. If you have any questions or queries about anything that we've raised during this webinar, or would like to discuss the bill with us generally, then please do not hesitate to contact either of us. And we will be providing some further guidance once this bill has been enacted. Thank you very much for your time, and we wish you all the very best. Thank you.